Good afternoon, everyone, and welcome to the second session of our webinar series on the new Title IX regulations. I'm Tom Mercurio at the University of Vermont, and for myself and the whole UVM continuing and distance education team, thank you for tuning in and joining us. Some of you may have been here for our first session back on June 10th, in which we began our examination of the new Title IX reality. Today, for our second session on the new Title IX, we offer an Ask an Expert panel. You've got questions, we've got answers. Actually, the better title should be We've Got Questions, because we have a lot of questions that have already come in. So I'll try to move quickly to getting our panelists introduced so we can get started. Our first panelist is Dana. Dana is an Associate General Counsel. Before that, she was the General Counsel at Dickinson College. Dana, welcome to the team here at the University of Vermont's Legal Issues Conference. Dana tells us that she's in a thunderstorm over in New Hampshire, may have some connectivity issues, but Dana, are you with us now? She seems to be here.
I hope so. Can you hear me? Hello?
Welcome, Dana. Next is Joe Storch, who is the Associate General Counsel for the Suny system, the State University of New York. Joe's honors and achievements are many, but I'll just note that he led the team that recently assembled and posted the joint guidance on federal Title IX regulations. Joe, am I right that that document is publicly available to all?
Absolutely.
Excellent, thank you.
And maybe we could put the link in the chat.
Yep, we can certainly do that. Third is Jeff Nolan. Jeff is a Vermonter with a long and distinguished career in higher education. Jeff now conducts a... Jeff, welcome back to our summer webinar series. Jeff was here back on June 10th for our first presentation. So just a quick question to my staff. Remind us how our viewers can submit questions. In the chat box on your screen. I don't see any yet, but we'll try to keep my eyes on it. Great. The first question is from Nicole. We'll hold that one for the moment. I want to go back instead and begin with the questions that came into us through the internet before we began this afternoon. And I've tried to group them together into clusters around common themes. The first cluster has to do with this question of jurisdiction. That is, that the new definition of Title IX of sexual assault or sexual violence under Title IX includes a smaller number of offenses that fall within the rules. And it obliges us to dismiss those that fall outside that definition. So the first question or cluster of questions is, what do we do about misconduct that falls outside this definition but is still unacceptable? The exact regulatory language, a part of it is that dismissal does not preclude action under another provision of the recipient's code of conduct. So what might that other provision look like? Can it be the same policy and process but with different definitions? Must it be a different part of the institution's code of conduct with a different process? Does it matter if the dismissal is discretionary or mandatory? Dana, can I turn to you to begin with your discussion of the jurisdictional questions?
Dana, I heard.
Oh, there you are.
Okay. You're all frozen.
We're all frozen?
I'm not sure this is going to work. We'll try. Yeah.
Did you hear the question?
Anyway, I heard the question. Yeah, there's obviously this is a point of intersection of our standards as a community with the intersection of the new regulation, and the mandatory dismissal of non-Title IX allegations from other conduct allegations has created, I think, both opportunity and challenges for institutions. And to me, it's almost like a Venn diagram. We could certainly have the code of conduct violations overlap completely with the Title IX process, although I think that's a challenge because the Title IX process is so fraught with procedural complexities that are not required of colleges and universities in any other forum. They can be completely separate. You can dismiss one, initiate it over separately in the other, or you can try to run them in parallel. And running them in parallel is difficult because if you have different procedural standards, understanding what you're doing in what aspects of it is going to be complicated. I think there's a lot that can actually still be salvaged out of the conduct processes we had in place before the new regulation that still works. And if the conduct that's alleged is not required to follow the Title IX process and must be dismissed, we already have structures in place for dealing with that if we label it appropriately as being within our code of conduct, so that we're not in a place as we try to hit that August 14th implementation deadline where we have to reinvent the wheel completely. We can take what we had if the matter, let's just say we have a sexual assault in a program abroad that does not fit the new parameters for being within a program or activity within the United States. We still have a place for that where we can review that conduct and hold people accountable by institutional standards. So there is that possibility, but how you run them procedurally, whether you try to run them together or side by side or to try some intersection, those are opportunities for schools to consider what best fits their need and their organization. I do think it's important that they be separately defined, whether the definitions are similar or not, but that they be separately defined under a code of conduct, because I think it would behoove all of us in the age of the new regulation to not look as if we are trying to dismiss on a discretionary basis and then rehear on a basis that we view as more favorable to the institution or more favorable to a complainant or respondent, depending on the circumstances. So those are my initial thoughts. And I welcome input from Joe and Jeff.
Gentlemen? Does it matter if the dismissal is mandatory or discretionary? I'm guessing it doesn't. Either way, the institution has a lot of leeway to design its parallel process.
I don't think it matters. Are you asking Dana or me? Go ahead, Dana.
I was going to say, I don't think it matters. I agree with Jeff, and I'll let him answer more completely. Although from the number of questions that we had submitted before this webinar began, I do think people are anticipating that discretionary dismissal could be abused. If that is in fact a concern, you need to be on the lookout for that. And like I said, if you're doing it in a manner that either party could perceive as being done to favor the other party or the institution, you need to be on the lookout for that. But based on the bases for discretionary dismissal that are set forth in the reg, I'm not as concerned about discretionary dismissal and as some of our participants might be.
Thanks. Jeff, Joe?
Yeah, I agree with that, Tom. I think that I think the idea of discretionary versus mandatory dismissal, basically you can't use discretionary dismissal as a means to do an end run around the requirement that anything that fits within the definition of Title IX sexual harassment must be adjudicated under the procedures laid out there if you're going to adjudicate it. So I don't think saying if it may be dismissed for one of the reasons in the may be dismissed language because the complainant doesn't want to participate any longer, or the respondent has left the employment or the student body, or there's a problem gathering evidence, that's all the may dismiss language. If the school still wants to go forward and decides to decline to exercise that discretion, I think it would have to use the procedures and not do a discretionary to get around the mandatory process. But the bigger picture that Dana referred to, I think where the department is a little unrealistic is the idea that we're going to handle Title IX sexual harassment within their narrower definition in a program of activity of the institution in the United States. And do that in a certain way and then do a completely different thing, or send it to a student conduct code that we might use to adjudicate stolen laptops or roommate disputes. Because those programs and those procedures were not designed for dealing with the kind of sensitive, high-stakes matters that we've been adjudicating over the last number of years, since 2011, then 2015 with the Clery Act, and those Clery requirements are still there, and they're not going to be present in your student conduct codes. So what I'm seeing a lot of schools do is to do one of two things. Well, I guess three. First, they have to decide, are they going to prohibit everything that they did before? Many schools are saying, yes, we are, even if the Title IX definition was narrower. If that's the case, what procedures are we going to run? Are we going to use the same procedures for everything, well, whether it's Title IX sexual misconduct and other types of sexual misconduct, even outside of program activity, study abroad, etc.? We're going to use the same process, even though that's extending some procedural rights of cross-examination and so on that we don't have to? Or are we going to run a process that's parallel but stops short of some of those more troubling procedural rights, like live cross-by advisors that we provide if they don't have one, like some of the evidentiary rules that are problematic? And I have clients going in either direction, and I think either can work under the rules, but I think the dismissal language is purely, we make a determination based on the allegations if proved. If they would be Title IX sexual harassment as defined, then we adjudicate it as such. If they wouldn't be, in our view of the allegations, we tell the parties that, give them an opportunity to appeal. Assuming the appeal does not change the decision, we can then basically say it is dismissed for purposes of Title IX and hereby transferred to this other process that may be in the same policy and procedure section of your code. It doesn't have to go to a separate student conduct code. It's not well suited for these. The must dismiss language is something ACE really pushed back against. Joe was involved in those efforts, as I was, as was Dana, and we didn't prevail. But I don't think the language is necessary. But we'll learn to live with it. It's just a matter of how you write your policies.
Thanks. Jeff, I wonder whether you might get your voice level up a little.
And
Either move a little closer to the mic, or if you have a way of just boosting your volume, that would be great. Joe, I'm sorry, you had a comment to add?
Yeah, I think, we actually are taking the opposite approach from a practical standpoint. We have and are pretty satisfied that our processes comport with due process. They've been tested, and the courts have found that they comport with due process. They comport with New York State law, and New York State is very active in the law in this area, as are a number of other states. So what I think is going to happen is that we are going to come out with a new policy. It is going to be very narrow in its approach. It's only going to apply to those specific types of behavior in the specific places, with all of the applications of the very, very tight definitions from the Department of Education. And it's going to say on its face that anything that does not meet these narrow definitions is covered under the Code of Conduct. It's also likely to say that if the final rule is enjoined by a court of competent jurisdiction, or if it is withdrawn by the Department of Education, that this, what we are referring to as our sidecar policy, is null and void. This is not something that came from the university, that meets our chancellor and our board's sort of moral approach to addressing harms that occur on our campus. And it's not something that, as an institution, SUNY believes in. I think I could say that. We issued 82 pages of comments to the department. The state of New York is currently in litigation with the federal government. So our policy is going to apply very narrowly. Our code of conduct is actually fairly robust. Sort of to Jeff's point, our code of conduct already includes notice and opportunity to be heard, advisors of choice, neutral hearing officers. It includes at least one level of appeal. That appeal is heard by a panel. That's all covered in state law. So while I hear that for a private college that might have been using a single investigator model, that the differences between the new Title IX final rule obligations and the traditional single investigator or hybrid model are fairly stark. For us, I think everything is going to fall under the Code of Conduct unless it narrowly falls under this new Title IX policy. And if that policy is withdrawn in a future administration or change in a future administration, or if it's enjoined by a court, we will simply lop off the sidecar and return to our approach that we've used for, say, 40 years. So just different approaches.
Great. Great. Thank you. Other comments, Dana?
The process that we're following basically the same outline that Joe describes as Dartmouth continues its review of its policy, and that is that the new policy we are envisioning at this point as being very narrowly subscribed to address only those issues required by the new Title IX reg. And we do have an existing sexual misconduct policy which differs from our broad student code of conduct, which is quite robust, and in addition to dealing with petty matters, also has a formal process for dealing with serious crimes like assault and drugs, etc. But the code of conduct, the student sexual misconduct policy, which now exists and which we propose will continue to exist for those issues outside the Title IX reg, does meet all the procedural requirements for private institutions of fundamental fairness and fundamental due process, not the robust 14th Amendment variety. So it's not tremendously different from what Joe is describing as happening in a large public institution.
Great, thank you, Dana. I'll move on to the next little cluster of questions, and this has to do with the part of the rule that reads, and I quote, "At the time of filing a formal complaint, a complainant must be participating in or attempting to participate in the education program or activity of the recipient with which the formal complaint is filed." So some of the questions around this topic are, what does this mean for non-students who suffer sexual harassment in a context within university control? One example, suppose a senior in high school attends a college football game and suffers sexual harassment, which meets the definition under Title IX. And the perpetrator is a university student or professor. The young person later applies for admission to the university after the incident. While not yet admitted, that person files a Title IX formal complaint regarding the incident at the football game. Wouldn't that person be a proper Title IX complainant even though he or she is not yet a student? Anyone? Jeff?
So the person is a complainant at the time. Is my volume better now?
Yes, thank you.
Okay, I switched mics. So the person is a complainant as defined at the time of making the complaint, and the reg language itself doesn't speak to when the conduct they're reporting happened. So I think to be on the safe side, I probably would accept it as a complaint, as a formal complaint by a complainant if it met the other requirements.
What if there are other non-affiliates who seek to file complaints? For example, is it enough to say, well, here's one example. What about dual enrolled high school students taking college courses? If sexual harassment occurs in the classroom of one of these dual enrollment programs, does the high school or the university Title IX regulations apply? Thoughts?
So it appears to me from the preamble that the rights that the Department of Education is concerned about really run with the respondent. So it appears from the language of the respondent that if a 12th grader taking a class at one of our community colleges reports that a fellow student who is a first-year college student sexually harasses them, the rights and the system go with the respondent, and so it would be in the college. Interestingly, you know, if the first-year college student reports that the 12th grader was harassing them, well, those rights would be adjudicated in the high school. You know, assuming that you know, they were in high school for I don't know, they were there for student teaching or something like that. And that is a real concern of ours. At Suny, like in many institutions, we have a lot of different universities. We have our students We have students who are in our classes. We have online courses. We have all sorts of different approaches. And it is very concerning to me that a 48-year-old civil rights statute is now defined by who is the respondent, making sure that we protect the rights of those who are accused of the harassment, whereas the high school student, or make it even worse, a kindergartner who is sexually harassed by one of our students in student teaching in kindergarten, if that kindergartner, and I'm not making this up, it's in the preamble, if that kindergartner wants to take action against that harassing college student who harassed or, God forbid, assaulted a kindergartner, that kindergartner would have to submit themselves to cross-examination, lest all of their statements that they made, that they want to make, that they made to law enforcement, to social services, to their parents, would be barred. And since no kindergartner, and as the parent of a recent kindergartner myself, is going to let their child go through that, it means that our students or employees would be free to offend again. They would say to us, well, I've been found not responsible because no witnesses showed up. I want back into a kindergarten classroom. And for public institutions, I think we're going to be in a very, very difficult position. Maybe privates will be in a better position, but that is certainly something that's novel.
If a would-be complainant is ineligible to lodge the complaint because they're not participating or attempting to participate in an educational program, can a Title IX coordinator sign a complaint on that person's behalf and have it go forward in that fashion? Jeff, you're nodding your head yes?
Yeah, that is a good example of what the regs mean when they say the Title IX coordinator may sign a complaint even without a complainant who files a formal complaint. So that is exactly, and I know we had several pre-submitted questions around third-party complaints, and that is one of several examples of exactly when the Title IX coordinator can sign a complaint and move forward. And so yeah, definitely.
Thanks.
And I think Jeff and Dana would agree, though, that it presents some challenges. If the person is not even willing to go forward with a formal complaint, the likelihood that they are going to show up and be cross-examined, I think, would be on the lower likelihood side.
Yeah, this hypothetical is more the one where the person wants to participate in the process. They're a willing reporter. They don't fit the definition of complainant because they're not attempting or participating in a program. So you anticipate you actually are going to get to a hearing where they participate. But you're right. The ones where the person's not going to appear and it's the Title IX coordinator hoping that it will move forward in the absence of them, they're going to have to make a decision about whether there's any point if they won't show up at a hearing.
Thank you, Jeff.
Let's also not forget that this is exactly the kind of opportunity to use our pre-regulation processes for as well. Merely because it's not a Title IX violation does not mean that it's conduct that we cannot regulate on our campuses and that we cannot resolve through our code of conduct processes. So I question whether, even though the Title IX coordinator could file a complaint, is this the kind of thing we want to subject to the procedural hurdles of Title IX if we're not required to, or do we want to make sure we have the flexibility to resolve it in a manner that is fair and impartial, but perhaps not as procedurally bound?
Absolutely agreed.
We have a question from Jordan about informal resolution. Jordan sees information mandating an informal resolution. I'm not quite sure I agree that that's what's mandated, but what's the best practice, or what guidance can we offer about informal resolutions in the scope of potential results? Anyone? My understanding of the regulation is that it allows but does not require informal resolution. I would imagine, though, that almost all of us have a very strong interest in having something like that available, and I would imagine that the regulations are very prescriptive about how that looks.
Well,
Joe?
it's certainly
Generally, that's.
required. Go ahead, Joe.
I was just going to generally agree. Jeff, why don't you start?
I mean,
Jeff?
certainly informal resolution is allowed, and the regs are framed in terms of institutions will not require people to participate in informal resolution of Title IX sexual harassment. Somewhat curiously, you've got to have a formal complaint of Title IX sexual harassment before initiating the notices and so on that you need to give about the availability of an informal resolution process. But if you have a formal complaint that fits within Title IX, you may do informal resolution. You give them notices about how it works, and evidence is going to be used. What can be the potential results and those sorts of things. I mean, the literal language is in the reg. It's pretty clear. You give that notice, and if the parties decide they want to participate, they can. One of the big things schools are going to have to decide as they draft that policy is at what point are they going to say it's over, it's done. You can't go back to a formal process. Typically, I think schools will want to at least say, once we have a signed document that resolves the matter through informal resolution, you can't go back later and go to a formal process. But they probably will want to allow for parties to opt out of the informal resolution process and go back to a formal process before they get to resolution. Question of remedies, I'm interested in others' thoughts on it. I've always thought that even from the notice of proposed rulemaking, theoretically, you could have an arrangement where a respondent agreed to sanctions. Some folks are thinking, well, that's not likely to happen, but I don't think the regs preclude that. I think you could have a situation where a respondent says, hey, I'll take a semester suspension over the prospect of expulsion. So yeah, that's what I'm going to do. Whether that's practically going to happen or not remains to be seen, but I don't think the regs preclude it. But I'm really interested in Dana and Joe's thoughts on
And I think that's what we would have typically, we have a lot of students who take responsibility for certain actions under our standard code of conduct. Maybe a bit less so in crimes of violence, but think about your typical, your roommate violence, your drug and alcohol. We have a lot of students who accept responsibility. There's not really room for that under the formal rule, under the formal grievance process. So even that standard 1960s and on process of accepting responsibility would itself be informal resolution. So we got to have some kind of informal resolution, even if it's just a student accepting responsibility and indeed perhaps taking a sanction that's less. But note that the complainant in that case could back out of informal resolution. So, when we take a drug case, a roommate violence case, the respondent accepts responsibility. We don't generally go back to the other party to say, do you agree or do you want to go back into the hearing? And generally a respondent who accepts responsibility will get a sanction that's less than they were facing at the hearing. Here, there's an additional element because the complainant can appeal that or frankly can just drop out of informal resolution, say I want to go all the way to a hearing, and so it is a bit more complicated.
If an allegation begins in an informal resolution process, can information gathered during that process be used later if it does go to a formal hearing? Not sure the rules address that.
It's addressed in the preamble, and the department very narrowly says, well, I guess so, but you should probably think about your policies and whether you want to have a policy that addresses that. So technically, yes, but from a practical standpoint, who's going to participate in an informal process if it's like mediation, like the old rules around mediation or arbitrate, that kind of thing. If it's going to go back in and be used against you, nobody's ever going to negotiate any type of resolution. So the department says, yeah, sure, you could use it, but you might want to have a policy addressing it.
What about incidents between employees that don't involve students at all? For example,
Yeah, I just would agree.
I'm sorry, Dana? Okay.
I was just going to agree with Joe. I don't think allowing individuals is going to encourage many people to participate in an informal process. If we have the flexibility under the new reg, particularly given the ambiguity in the preamble, I would suggest fixing your informal process to not allow for the use of information there in or the other decide to move it in a different direction.
Thank you, Dana. A quick question about it, incidents that don't involve students at all. Say there's two staff members who one alleges sexual harassment against the other. Would the formal grievance procedure still apply? I believe the answer is no. That would be a Title VII rather than a Title IX matter. Right. The Title IX would not apply to a strictly employee-to-employee situation.
No, we're disagreeing with you, Tom.
Oh, you are? Okay, let's hear it.
Yeah, sorry. It's bad news. You're not going to like it. I'm going to let Joe tell you. He's going to tell you all about it. You're not going to like it one bit.
Make me the bad guy. The department, and they did not, we didn't expect this to be coming based on the notice of proposed, and I went back and looked at the language and said, oh my God, did I miss this when we did our comment? And indeed it was not there. They would apply these Title IX processes to student to student, student to employee, employee to employee, and as you know, many attorneys, I know Scott Schneider, who many of us know did a great webinar on this specifically. Many attorneys have pointed out there are things that Title IX says you cannot take action on that Title VII says you must take action on. And boy, are we going to be in a tough situation. 17 anonymous complaints by one employee against another employee, or 17 employees who come forward and say, I want to bring this forward. I wish I could, but this person is going to ruin my career. Title VII says you better go in and investigate, especially if it's severe or pervasive. Title IX says it has to be severe and pervasive and objectively offensive and essentially eliminate access to education. So it's applicable and it's bad.
Okay, thanks for correction. I appreciate it. I'm going to jump to another topic, if I may, and that's questions about advisors. One of our viewers has asked whether a school can have one advisor for the person coming into the process, bringing their allegation, and a different advisor for the purpose of the hearing, for the purpose of conducting cross-examination. Any problem with that proposal? No prohibition that I'm aware of. We could certainly, you could set it up that way.
But just to be clear, you don't have to provide an advisor before the minute the hearing starts. That's the big distinction. And you know, the way the regs are set up, if it's not specifically precluded, the department says it's giving discretion to institutions to run their process. So they only require advisors show up at the hearing to do the cross basically as the voice of the party, even if they don't really have much skill as far as the department is concerned. But you don't have to provide people earlier.
Despite what the department says about the advisor not having much skill, what are our thoughts, or what are your thoughts on what the qualifications of an advisor should be, both to promote fairness and to avoid subsequent claims against the school? Dana, thoughts?
The advisors are required to have training equal to investigators and hearing officers with respect to relevance and with respect to the training requirements. They are not expected to be lawyers, but I think one of the things that makes all of us nervous, whether we're public or private or large or small, are the inequities. If one party has an attorney advisor and we appoint an advisor who's from our pool of faculty volunteers or staff volunteers. There is an art to cross-examination. It is a skill that those of us who are lawyers on this call many of us have been trained in across our careers. And while the regs say we're protected from being deliberately indifferent if we appoint a qualified advisor qualified in those very basic ways of our policy and their obligations, the equities really concern me about having disparately qualified individuals in hearing.
Any thoughts about a solution for that dilemma? You know, in other contexts, we've talked about how it may not ever work at all to have an employee of our institution be an advisor. Even though we're obliged to provide an advisor, the idea of providing one who works for the institution carries risks that may not be really very tolerable. And then my question would be, could we sort of switch and trade and have each other's institutions provide advisors, say across town to another school, to avoid some of those conflict problems? Thoughts about having there be a collaborative effort to provide a pool of advisors so that you get someone who doesn't work necessarily at your school, but who has had the same necessary training? Jeff?
I think it's better than the alternatives of having to deal with this argument that the person you provided was somehow biased because of their connection with the institution. You know, the regs in the preamble talks specifically about, you know, we don't worry about advisors not having a conflict with the party. In fact, they're supposed to be conflicted against the other party in a sense because they're adversaries in that way. I think, like you say, Tom, faculty and staff in those positions, particularly on a smaller campus where their involvement in something that could involve cross-examining a party could be very sensitive and difficult. I think they might hold back. I'm concerned about it. So the idea of using someone else from other campus, tapping law students who, you know, if you're not going to provide attorneys in the way that maybe Dana's suggesting in cases, that at least they have an understanding of the importance of process and are willing to be advocates in the way that you need to be. Maybe that's an option. But there aren't really easy answers to this, and I think it's going to play out over time. Thinking through, and we've all done this, you know, what, in the end, first we want to be fair, but how, to what links are we going to be fair in terms of trying to link up the respective purported skills of the various folks? And then secondly, what are we thinking of in terms of legal exposure for doing what the regs say? And it's not easy. It's not easy. I will argue that we're not facing legal exposure because the regs aren't creating, you know, civil private right of action, and it's not deliberately indifferent to follow the reg. Nor does it demonstrate bias because we do the same thing if the other party didn't show up without an advisor. But I'm interested in anyone's thoughts. Maybe Joe can fix this for us.
You know, we're going to try to set up a structure so that our faculty and staff could successfully serve as choice under these very narrow standards given to us by the department in the final rule. They claim in the preamble the person does not have to be an attorney. They don't have to be have any kind of specialized background or anything like that. In fact, they could be nothing more than a vessel for simply reading out neutrally a list of questions. And so we're at least at the beginning, and while I understand that some institutions are saying, well, should I hire this, should I hire that? At Suny, we're not in a hiring position right now. This is COVID-19. We're basically, what we've got is what we've got for some time. So we are going to build a system that is going to try as hard as we can to delegalize what appears to some to be an extra legal process. And we even have some thoughts around we're going to put out a decorum policy. The department says in the preamble, you can regulate decorum. Well, guess what? We're going to regulate decorum. We're going to put in all sorts of things that try to bring it back down as much as possible to a neutral asking of neutral questions, or at least neutrally phrased questions that are attempting to obtain relevant evidence, more probative than not that something did or did not occur, without, we don't want to create, you know, what everybody sort of thinks of as cross-examination in episode of Law and Order, or Tom Cruise and Jack Nicholson, you know, screaming at each other. So if we are successful in dialing down the temperature, there's no reason that one of our faculty or student affairs staff members shouldn't be able to serve in that role. And agree with Jeff entirely on the legal liability issues. I'll take the department at their word.
Great. Thank you. I want to move to another group of questions involving another aspect of the regs that I know is particularly vexing to many of us, and that is the requirement that someone's statements cannot be considered unless they submit to cross-examination. So one of a cluster of questions about this topic. First, if a witness during the investigation provides an account, provides some statement, but tells the investigator that that person has no intention of being cross-examined and appearing at the hearing, should the investigator even include their statement in the report at all? Joe?
I believe they have to because the requirements of including information in the report is actually wider than relevance. So you have to include information that is, and I'm forgetting if Dana or Jeff remember the phrase that they use for what you need to include in the report. I think it's directly related. Even if not
directly related is what you have to provide to the parties for their review. You could still decide as the investigator to only put relevant, right? So the broadest category is directly related. Then there's relevant as you determined by the investigator. It's determined by the investigator.
And so ultimately, if the Title IX investigation report or that evidence were to come in during the hearing process, an instruction would have to be made to the hearing officer not to consider uncrossed statements. So in that example, I think it would become part of the record, but it could not be considered by the decision maker in making their ultimate determination of responsibility.
So I'm hearing some agreement that there's no obligation for the university to go through and comb out and redact or remove these statements. There simply is a direction that they can't be considered at the final decision stage.
I think you can wait till the hearing occurs. You know, the person can say, I'm not planning on showing up, I'm not going to show up, but as far as the reg is phrased, if a party does not submit to cross-examination at the live hearing, the decision maker must not rely on any statement of that party, blah, 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 in reaching a determination regarding responsibility. So that's really, they could change their mind. So I'd put it in the report because then you've included, if you deem it relevant as the investigator, put it in the report. If it's directly related, the parties get it anyway, then you narrow it to relevance, and then you get to the hearing and the funnel narrows further to only those statements that are subject to cross-examination, or the people that made them are subject to cross-examination. And that's what the decision maker is ultimately going to have to deal with. As far as redaction goes, I think it's going to be a tough one to redact because typically you're going to want, again, to wait and see what happens at the hearing and who shows up to be cross-examined or not. And you're going to want to provide, I would think, your investigation report to your hearing officer decision maker beforehand so they know what the case is about, so they can be efficient in forming their questions, for example. But Joe, I don't know what your thoughts are on that, or Dana.
Well, what if a witness or party appears at the hearing, begins to answer questions on cross-examination, and then at some point says, I'm done, I refuse to answer any further questions? I mean, is the entirety of that person's previous statements now excluded, or can they parse out what the person was cross-examined about and what they weren't cross-examined about? Can the prior statement evidence be saved by the decision maker asking the same questions as the cross-examiner asked without success? Forgive me, maybe I'm asking questions that don't have easy answers.
Well, and I would ask Jeff or Dana, I don't know the answer to the first one, because the department says, if you look at just the text, that no statements can be considered if they don't submit themselves to cross-examination. How much cross-examination? An hour, 2 hours, 10 hours, the remainder of their natural life? One question is enough? There's no evidence that, so let's say there were 3 incidents and the person is successfully crossed on incident 1 and on incident 2, and then on incident 3 they have a heart attack and they leave and they're never heard from again. or they leave the country or whatnot, can we consider their statements on incident 1 and incident 2? I think based on the plain language, the answer is no, unless they submit themselves fully. And that is fairly extreme. That would not be the case in criminal or civil court, and that's fairly extreme. Imagine also you have an academic medical center that serves seniors, maybe seniors who are terminally ill, who are participating in an academic study, and the person who is conducting the study is accused of sexually assaulting them. To the extent that those terminally ill patients pass away before you get to the lengthy process of the hearing, you won't be able to use anything that any of them say ever. And to the extent that something is covered by this, you can't go Dana and my route that we described earlier, where we'll just go under the code of conduct or the employment policy. It is essentially a permanent get-out-of-jail-free card, and maybe you have some other options on the private side. On the public side, to the extent someone is found not responsible, it's going to be hard to take any kind of action against them from a disciplinary process. And that, to me, is the scariest setup. Children and terminally ill patients, individuals with disabilities, folks who will just never be able, I'm talking about severe disabilities, should not be able to successfully testify and submit themselves to cross-examination. They will face significant.
I think this is probably, so much focus was paid on the live cross by advisors and that being so difficult. I think this evidentiary rule, which apparently was written in an attempt to be simple so that even non-lawyers could administer the hearings, is probably the worst, most difficult as far as relation to common sense, because the idea that you can't rely on, the way it's literally phrased, the idea that you can't rely on anything that the person had to say if they and be cross-examined on if they refuse to be cross-examined on 1 or 2 questions out of 3 hours. I'm going to argue for clients, I'm going to argue you can go forward and base your case on what they answer questions about. If there are certain things they don't answer questions about, so in Joe's hypothetical incident number 3, you probably can't. But the literal language that says, it argued that failure to answer 1 question out of 75 questions about 1 incident should scrap the entire, what does answering mean? I don't know, I forgot, is it really full? Forget it. I'm going to go with substantive is close enough here. That's an argument, that's not legal advice to anyone, but it's one I would plan to make. And, and it's interesting, Joe, as you were talking about the, someone who's a complainant who is maybe not going to be available because of health reasons, I might even tip to the process we follow in civil matters, which is have a substantively identical hearing, but have it on that point only, even if you've got to postpone other parts of it somewhere else. Basically preserve it, so long as everybody gets to participate as if they would. If I had if it's going to be 6 months, it's not going to work. But if it's a difference of a week, and the person's able to participate, and then they have to go to, Europe or something, and it's irrevocable, I'm going to preserve their testimony and do it all substantially the same.
And I think the week one is very much a possibility. One of the things, because I thought of your process initially, say, well, maybe we'll film the. I think the fun is. Oh, sorry, Dana. Please.
I'm sorry, Dana.
I say I apologize for the. I'm here.
Thanks.
Can you hear me?
Yes, we can hear you. I can see you now too. Welcome back. It's nice to have you back. Actually,
Can
I want to
hear me?
We can hear you. Can you hear us?
We can hear you, Dana. Go ahead.
I can. I was just going to say, I apologize for the technical difficulties. I live on a dirt road in a thunderstorm, and technology is challenging. Anyway, I don't disagree with what Jeff just said, but it points out the complexity. When Jeff is talking about basically a deposition to preserve testimony, we're talking about a process which isn't available to our students equitably, and how there's so many challenges that that the new procedures present to us, and that is but one. I think there is a way to read that. I don't disagree with Jeff's plan to basically do issue preclusion, and actually I hadn't thought of that, so that's something I'm going to take back in my own things learned today as a possibility. I think it's edgy based on the position in which the regs expect us to treat people who don't cooperate fully. But lawyers or non-lawyers, and this goes back to an earlier opportunity when I couldn't comment, which is I think this right now, there are many opportunities for pop-up boutiques to provide rotating advisors, rotating hearing officers, or ones for sale for a per hour cost or per diem cost, because this is complex in a way that no other process we have ever had has been. And it goes to Joe's comment earlier about making sure we circumscribe the reach of the Title IX process very narrowly, so we don't end up imposing these standards more broadly on our institutions.
Thank you, Dana. Stay with us, if you will, for the next question. I want to shift to a different topic. One of our viewers online has asked about the role of the Title IX coordinator, and it appears from the regs that this person cannot be the investigator, but can that person, are there other limitations? Can the Title IX coordinator be the final decision maker or the hearing facilitator? Joe shaking his head no. Dana, what do you think?
I think absolutely not. The regs are very clear that they've made very clear that these roles must be separate, and the Title IX coordinator nor the investigator can serve as the hearing officer. That we've created, we now have very clear expectation that these roles will be separate.
Could the only piece of that is that the Title IX coordinator can be the investigator. They cannot be the decision maker, appeals officer, advisor, any of these other roles, but a coordinator can be the investigator, especially that don't have as many people.
Okay, so the Title IX coordinator can be the investigator. Can they be the facilitator of an informal resolution?
Technically, yes. I think we've been advising that is a very bad idea because, there's going to be an accusation afterwards that they played multiple roles and that there's bias. It is technically allowed under the preamble. It is, I think, not a best practice.
The argument would be that they learned things during the mediation process, that they, admissions made by the respondent or the complainant about their conduct on the incident day and all of that, and that they subliminally somehow affected the process later by it. They're not going to be the decision maker, so it's not quite as bad as if the decision maker was varying statements and offers back and forth. But it's still a tough one. I probably wouldn't source that role with the Title IX coordinator. I could avoid it.
So we're getting close to the end of our time, but there are a few other sort of miscellaneous questions we may have time for. I'll grab a few if I may. The first is that looking at the date, the implementation date of August 14th, if an incident occurs before August 14th but is reported after August 14th, which rules will apply?
I think the department hasn't made up its mind on this question yet. I think they have not concluded how they're going to require schools to go forward. I don't think the regs provide either way. And there might be safer routes and less safe routes. For me, the safest route is probably to apply procedures after the 14th of August that comply with the new regs, even if the conduct happened before. But you're just less likely to get arguments from either party that they didn't get some right that they said would have changed the outcome in this case. But I don't think the regs really say, you know, maybe the department will come out with something. They write a blog and so on. They've clarified a few points around IT and some other things. Maybe they'll address this, but I don't think they have yet. We'll find out soon because we're going to, I mean, at least we're not on campus right now, but we're still going to get complaints of behavior that happened while folks were on campus that people are now feeling safe enough to bring forward. So the issue will have to come forward.
Do the regulations require a specified time, a number of days for each of the grievance process? Or do they merely require a time frame for the entire process, the 60-day requirement that we're working for?
I'd say it's a little bit of both. There are definite time frames specified in the regs with like a minimum of 10 days to review the initial report, 10 days to respond to this and that. But it does not set a time frame overall like the 60 days from 2011. They just have, our processes have to be prompt, and that we all realize. The additional flexibility that the reg gives us is that they don't define days. So we have a little more flexibility in our processes as opposed to business days, school days, calendar days. We even have a little bit more flexibility around how those prescribed timeframes are used in our process. Every school that's on this call recognizes that 60 days, whether the 10 days that are specified here and there in the new regs are going to actually be adequate, we're going to all have to figure out what's going to work on our campus. Have some flexibility under the rules to complete various phases of the process without boxing ourselves in fixed time for completing it.
Thanks, Dana. We're just about at the end of our time, so maybe I'll turn to you just first. Actually, first of all, three of our panelists, and ask if you have any last-minute words of advice you'd like to share before we wrap up the program. Dana, anything?
I'd say let's just be hopeful for success by some of our colleagues, like Joe Storch's school, in the challenges that have been filed to the new regs, so that we can end up in a place that is easier for our institutions to understand and implement. And failing that, do the best you can to hit the August 14th deadline, and just do your best. It's uncharted territory in my many, many years in representing higher education institutions. This is a new era.
One can always hope. Joe, any closing thoughts? Joe, I think you might be muted.
Sorry about that. I just want to thank you and UVM for hosting this, and to say that we are all in this together. And Jeff had mentioned at the beginning the joint guidance we created among a number of institutions and law firms that's completely free, and you've got colleagues across higher education who are working together to share documents and analysis, and hopefully that helps institutions. It's an incredibly drastic time in higher ed overall with everything happening, and to have this on top of it is very unfortunate, but at least we have each other, our colleagues, to try to help each other out.
And we have you, and we're very grateful for that. Thank you, Joe. Jeff, any closing remarks?
So quickly, a couple of things we've talked about, live hearings with cross, and some of these evidentiary rules are going to be really hard, but I've been working with lots of schools who have said, let's work to make our policies as much as we can as they were before, and continue to address misconduct in thinking about the people involved fairly, complainants and respondents, as well as we did before. And it can be navigated. There are challenges posed by these regs for sure, but kind of work with your Title IX coordinator, work with counsel to navigate the things that you need to, but recognize fundamentally this is really about the people involved, your staff, your students, your faculty, who are in really difficult circumstances. And well, it's not easy for us. We can get this done on the procedural side of things. The people involved are really the ones who are engaged in really life or death or life-changing circumstances. We'll get through this from the procedural side of it.
Right.
So keep some optimism. There are worse things in the world than these regs.
That's a good closing thought. There are worse things in the world than the new regs. Thanks again to all of you, Dana, Joe, Jeff, and on behalf of the UVM Legal Issues in Education group. Have a great afternoon. Bye-bye now.
Thank you.